back to What is Trending. My name is Angelo Himalayas, and this is Nation's Voice Tower. Political history continues to unfold while the APC, and which is the ruling party, and the Independent National Electoral Commission, which is the electoral umpire of the country, have since asked the Supreme Court to dismiss claims by Peter Obi and the Labour Party, and his Labour Party, and of course his deputy, Dati Baba Ahmed. They have asked them to dismiss their own lawsuit, countering claims that Obi was a member of the PDP at the time when he was welcomed to the Labour Party, alleging that he was in fact not a genuine member of the Labour Party, specifically on the 24th day of March 2022 during his screening. So talking about this, or to talk more on this, on Arise News, we have a lawyer and the former director of legal services and voter education for the Independent National Electoral Commission, talking about Mr. Osaze Uzioluole. He's a magician, and he's a guru in this field. So he's going to tell us what counterclaims the INEC have made to the Supreme Court in order to annul the petitions of the Labour Party and its candidate. Watch him explain it critically.
As you said, has gotten to a critical stage. The votes have been cast, the results have been announced by largely, especially in the presidential case. There's a dispute resolution mechanism outlined in both the Constitution and the Electoral Act, and it says that, look, if you are dissatisfied with the outcome of the elections and you don't think the person who has been declared a winner and returned as elected, you don't think he's qualified, or you think there's been substantial non-compliance with the Electoral Act, or there's a deviation from laid down rules and procedures outlined for the election, then you can challenge the outcome by way of an election petition in a court of law or competent tribunal. For the presidential election, of course, it's the Court of Appeal sitting in its original jurisdiction to hear the presidential election petition. That's how it is. It's been a hectic time for the lawyers in the commission. Prior to the election,
it's also a lucrative time, isn't it?
Well, within the commission, I don't know how lucrative it is.
Okay, well, but I mean generally, outside.
Yes, yes. I know that in one of the petitions, I think the lawyers involved are volunteers. They are volunteering their time, some of them are volunteering resources. So not particularly lucrative, rewarding, but not necessarily in financial terms. Right. But the others, I think, will be rewarded handsomely, financially speaking. Those with deep pockets will get even deeper, So they've taken some of the best brains in the industry, some of the very best lawyers in the land, experienced old soldiers in terms of election petition matters, senior advocates and other lawyers. It will be an interesting time. Stakes are extremely high. Some believe that we're as close as to annulment as it possibly can. Some think the petitions are quite frivolous. So it's a testing time. Yes, for those involved, there will be a full panel of the Court of Appeal to hear the presidential petition. That's 5 justices of the Court of Appeal. We don't know where they're going to come from. The president of the Court of Appeal has the discretion. She, I guess, will probably preside. It's almost a convention that the president of the Court of Appeal presides, but there's no law about that. I recall that in 1999, the president of the Court of Appeal, who considered the tribunals and considered the presidential tribunal, Court of Appeal to hear the presidential petition, sat the first day, but later on recused himself because his wife was a resident electoral commissioner in one of the disputed states. So he recused himself and replaced himself with somebody else. So 5 justices carried on with the matter.
Yeah.
Probably so. There are different schools of thought. In one or two of the Maghreb countries, I'm sorry, I don't know this, I can't recall the specific one, probably Morocco or Tunisia. The election commission comes in as more or less a witness. Come, present your case, and say how you conducted the election. Then the warring parties now deal with each other, fighting out amongst themselves. Some have suggested we should adopt that kind of approach. It turns judicial system upside down, but people say election petitions are use them generis. They are unique. They are different from normal criminal and normal civil procedures. So we should find a unique system a unique body of laws to deal with its approaches, both in evidence in terms of the necessary parties. But the law as it stands today, and as it has been for as long as I can recall, is that INEC is a necessary party in all election petitions, even if you're not complaining necessarily about the conduct. For example, if you say somebody is not qualified, he's a drug addict and has been convicted, or he's been convicted of an offense involving dishonesty, technically it doesn't concern INEC, because INEC has no right from the Supreme Court decision in Atiku Abubakar against INEC, Abubakar's case against INEC, that no matter who the party presents, you have no right to disqualify. Only the courts have a right to disqualify. So in that kind of case, people feel, why should INEC defend that kind of it doesn't concern it. It doesn't know anything about this person's qualifications or the disqualifying factors. So it should not be a party. But the law as it stands now, the Electoral Act says INEC must be a party in all of these cases and will be bound by the decision. For example, if it's held that the return was invalidly made for whatever reason, INEC, there's a legal fiction that it has to withdraw the certificate of return given to that person. But in law, once the courts are pronounced, that's it. So yes, some people feel that it's a drain on resources. No matter the number of petitions, INEC has to be a respondent. It has to defend the petition, and it's in the Electoral Act and in the schedule to that Electoral Act that you have to defend. And in the old Act, if you chose not to defend the petition, you had to seek the consent of the leave of the Attorney General of the Federation not to defend it. So by law, you have to defend it.
Right.
I think the present legal regime can be modified. I'm not too sure I want to go into a radical transformation of it. I think INEC should defend petitions. It's a big drain on resources. It's a big drain in terms of time and everything else. You are the custodian of all the documents. You are a custodian of the process. You are a custodian of all that transpired in the process. So you have a crucial role to play in determining the justice of what you did. Yep. You're quite right. And often, the last couple of days on social media, I have heard that expression. INEC is very much in bed with the APC. In states, it might be Labour Party, it might be PDP, it might be whoever won the election. But I was taken aback, with that, because we've been doing this for at least 23 years or 24 years, and that law has been the same. Going even further back, it has been the same that INEC has to defend the election.
Well, there are a lot of things we're doing in this country which has been going on for a long time, which really shouldn't be.
It shouldn't be. It shouldn't be. But you conducted the election. You were required to conduct it in line with certain legal framework and certain procedural steps you had to take. So it's only natural that you come and
welcome back. All said and done there. Welcome back. I hope you've really watched him there explain things categorically and analytically as it is ascribed to his own job and what he does and what he knows in experience and all ramifications. Thanks for joining us. Don't forget to tap the subscribe button. Don't forget to like our videos. Do the needful and watch this video to the end. See you next time in my next video.